Joe Biden did his pardons and clemencies a while back, and he did a ton of them. He did about 39 pardons and about 1,500 examples of clemency and reprieves. Remember, Chad, a pardon is a full relief from all penalty and punishment. Clemency is merely just a commutation of your sentence, meaning if you're in prison, okay, well, you're done now. You don't have to serve any more time. Or, for example, if you're on death row, you're no longer in death row. I'm giving you a reprieve. Now you're just serving life without parole. Remember, Joe also did this for a lot of Chinese spies, including the Chinese spy with 47,000 images of child pornography. Yes, that's a real thing. It's been an issue with some of these. Well, now, 2 guys in federal custody, they've decided to say, we don't want them. We don't want them. They don't want commutations. And there's 2 guys, Shannon Agofsky and Len Davis. They're both incarcerated at the U.S. Penitentiary in Terre Haute, Indiana, way down in southern Indiana, way down near the tip. And they both maintain their innocence. So they don't want to accept the commutations because they are fighting their cases. They're both on death row. They're both on death row. And we're going to go over their motions in a second. But Agofsky was sentenced to death in 2004 after he was convicted of stomping a fellow Texas prison inmate to death 3 years prior. He had already been serving a life sentence in murder and robbery, dating back to a 1989 abduction and slaying of a bank president, before he was convicted in the 2001 prison killing. So remember, robbing a bank is a federal crime, but also kidnapping is a federal offense. So guess what? He got a life sentence, and then while he was in federal prison, he killed a guy. And yes, killing another inmate is a great way to get the death penalty. Agofsky claims he's innocent of the bank president murder and disputes how he was charged in the stomping case. He's like, I didn't do it. I didn't do it. Len Davis is a former New Orleans police officer. Shocking, a New Orleans police officer in federal prison, I know. Who's convicted of hiring a hitman to kill a woman after she filed a complaint against him. And he got charged with multiple counts of civil rights violations. So these guys have filed motions in federal court. So they went to the Southern District of Indiana, and this is interesting. Like, if you can reject them, how is this going to work? Because normally somebody on death row would be like, cool, I want out. I want off the row. And these guys are saying, no, I don't want that. Now, here's the thing. Terre Haute is where they do execute people. That's where Timothy McVeigh was executed. So this is where it all happens. The first guy, Shannon Wayne Agofsky, he has an emergency petition for injunction from the commutation and the request of appointed counsel. Notice he wrote this all by hand, so he's got a bit of an issue here. And he brings it up at the end why he had to do this. He says to the clerk, please file the emergency petition. He says, I've been in prison for 30 years, so I definitely qualify as being indigent. But if there are still fees, please refer them to me and I will take care of it. And he says, apologies for writing by hand rather than typing. We've been locked down and I have no access to a typewriter. As this is time sensitive, it will have to suffice. And that's the thing, chat. Like, you get locked down in prison, so you don't always get access to a typewriter or a word processor. So sometimes you got to belt it out by hand. And if you want to write him and express your appreciation of his penmanship, there's all his information. I'm sure he would appreciate you being a pen pal out there. Anyways, he comes here to respectfully request the court block the commutation of his death sentence and prevent him from being resentenced to life in prison. So he talks about in 2004, while already serving a separate prison sentence, the defendant was convicted of killing another prisoner and subsequently sentenced to death. He says the main reason for the sentence was not the facts of the case. I was convicted of the multiplicitous and unconstitutional way in which the charges were filed, which confused the jury. This is evidenced by the fact the jury found the prosecution had failed to prove intent, which would legally mean the killing was manslaughter, yet they still listed first-degree murder as a death sentence. They still voted for first-degree murder. They say the defendant is housed mainly in the death row at Terre Haute, Indiana. And he says, while here, he has worked tirelessly to prove the actual circumstances of his case, as well as to establish his innocence in the original case for which he was imprisoned. After many long years, He is finally on the cusp of doing so. That's it, Chad. After 30 years, he's almost got it figured out. On December 22nd, the defendant became aware of the publicity stunt enacted by President Joe Biden, in which he commuted the death sentence of 37 federal prisoners, and he was part of this group. He says, I never requested the commutation. The defendant never filed for commutation. The defendant does not want commutation and refused to sign the papers offered with the commutation. It has been long recognized that the death penalty qualification process for capital cases, which assumes that jurors are willing to oppose a sentence of death, also tends to produce conviction-prone juries. That's not wrong. He's correct. Getting people who were willing to impose a death penalty are likelier to convict. This heightened level of risk is the reason why the doctrine of heightened scrutiny also exists, which enjoins judges everywhere to act with an increased level of care and consideration to ensure there are no mistakes when a life is at risk. The multiple charges inflicted upon the defendant, which led to his death sentence, were made possible by the Anti-Terrorism and Death Penalty Act. Anti-Terrorism and Death Penalty Act is a real thing. The AEDPA is a real thing. Guys, it's actually funny. Joe Biden, there's a clip somewhere out there on C-SPAN where he is proud to have created so many federal offenses that were death penalty eligible. He was proud of that. Remember, Joe Biden in the early 90s was very law and order. And he says, this ill-considered piece of legislation was authored by none other than Joe Biden. It has wreaked havoc on death penalty litigation ever since, and it has. It's been a mess. If you Google it through court, searching dockets, your Google's going to explode. And ever since then, findings of justice and difficulty for many, including the defendant. He says the current commutations are equally ill-considered. They fail to address any of the factual problems related to the death penalty, while inflicting additional problems on those who did not desire commutation, thus making it seem to be nothing but empty virtue signaling on the part of an outgoing president. This guy's pretty base, but remember, you're already on death row, so what the fuck, I guess. To force his commutation on the defendant would be to the defendant a victim of Joe Biden for a second time. The defendant's sentence was imposed under the heightened risk of a death-qualified jury. To commute his sentence now while the defendant has active litigation in court, it's to strip him of the protection of heightened scrutiny. This constitutes an undue burden and leaves the defendant in a position of fundamental unfairness, which would decimate his pending appellate procedures. It's for these reasons he files a petition. He is not seeking favors. He merely wishes for his case to play out in court as it was meant to, with the protection of heightened scrutiny and without the interference of partisan politics. Now, here's the thing. Let's say he gets his wish and he loses. Is he going to sit there pounding on the door saying, no, Joe, let me have it back, please? I don't want the needle. He says, therefore, he wants the following. He wants an injunctive relief to prevent the defendant's sentence from being commuted. He wants appointed counsel to aid in maintaining this litigation, which is necessary as the defendant is subject to transport at any time and may be unable to respond to the court on his own. And that's true in the federal system, especially. Boom, you're moved. You get you get minutes notice sometimes. People, when you're in the federal system, it's like you're getting transferred. So how do you figure that? How do you fix that? Because I've got a pending case and, you need a appointed counsel to help you, the public defender. So the other guy, his is a little more Sarah Boone-ish. But it's still got that flair. It's got that je ne sais quoi to it. So United States of America versus Len Davis. He's got the same thing. Emergency motion for injunctive relief. And about the commutation ordered by American President Joseph Biden. Reversing the death sentence to life in prison. And he wants a request to have co-counsel appointed to assist the prisoner in his matters. So he wants the same things. And he says, I was indicted in 1994 and a superseding indictment in 1995 in the Eastern District of Louisiana for a couple different charges: conspiracy against rights, deprivation against rights. These are civil rights offenses, chat. While acting under the color of law. That's at 18 U.S.C. 242. And then also 18 U.S.C. 1512, tampering with the witness, victim, or informant. So what did he do? He had someone killed. So He was convicted and sentenced to death by lethal injection on all counts, along with 2 co-defendants, one of which was sentenced to life and another who was sentenced to death, but is presently serving a life sentence after a reversal of sentence. So he said in 1999, his conviction for his 18 U.S.C. 1512 charge was overturned and dismissed by the Fifth Circuit, along with the death sentence, and converted to 2 and to reverse the convictions on both these counts. So it all got reversed. Well, it doesn't get better, though, because in 2005, he was retried and resentenced to death by lethal injection. So he got a round 2, and he went over 2. Actually, to be fair, he went 1 and 2. He got his appeal. He won the appeal, but then they sent him back. He's always maintained his innocence and argued the federal court has no jurisdiction to try him for civil rights offenses. I don't think that's really going to get anywhere, but okay. So he's always maintained that a death sentence, to having a death sentence would draw, I can't read that. Anyway, draw attention to the overwhelming misconduct of the Department of Justice in his cases. On December 33rd, 2024, Davis learned that the United States president was forcing an unconstitutional life sentence on him via a commutation order. He didn't request it. I didn't request it, and I don't accept it. He submits that there are a host of constitutional violations associated with the executive branch attempting to sentence the prisoner to life without his agreeing to the continuance. He says, all to be discussed in further entries. Well, thank you for making sure we knew that. Thank you for making sure we knew that, buddy. I'm glad you clarified that for us, that you were going to take care of this for us. So he keeps on going here, though. They say prisoner Davis refused to sign the documents presented to him today. So he wrote this like the day they got presented to him, acknowledging his acceptance commutation. It is unknown for sure if this will make this request moot. Of course, court will immediately be notified if something changes. This motion is followed in an abundance of caution. So, that's not a bad idea, really, if you're worried this is going to fuck over your chances of appeal. Although it's been 20 years since you were reconvicted, man, I don't think you're going to get out of this. He does advise the court we have video conferencing here on death row and can also receive legal phone calls from court. The defendant submits that the arguments made in this request are solely for the purpose of proving the president's attempt to commute defendant sentences is clearly full with constitutional problems. And this court has sole jurisdiction over the executive branch's decision. Well, close enough. And the defendant removed from death row, which is located in the state of Indiana, which is true. He's in the right spot in the right court. For these reasons and more, the defendant thanks court for its prompt attention to this fast-moving constitutional conundrum. And it is. It's a fast-moving constitutional conundrum. He's very correct. The case law on this issue is quite murky. It is true. Can you revoke your consent? I don't know. I don't know the answer to that. Signed by Len Davis. I mean, yeah, attention court emergency response request. Rod Breton saying there's already precedent for this. To an extent, there's precedent, but it's the idea, does this ruin their ability to challenge their convictions? Like all the whatever it is they're trying to appeal, does that negate their appeal? Is that the bigger issue here? Because if it doesn't change what they're doing, and it doesn't, it might affect them, and that's not clear. Now, here's the problem. They're going to have to make that argument, and the court's going to say, no, it doesn't. And then if it says, no, it doesn't, then I'm sure they'll say, fine, I accept it. But I don't know at that point if they've refused it, and now Trump is president, do those commutations disappear? Because let's say the court says, no, you don't have, if you accept it, it doesn't change your status. You're still appealing based on where you were at the time of your conviction. So you retain all those rights and protections and those enhanced standards of whatever it is you're trying to do. Let's say the court says, we agree with you. If you accept this, you screw yourself. So they reject it, and then they keep their appeal going, but then they lose. Are they allowed to go back and get it? No, it's going to be done. But let's say the court says, you guys are worried about the wrong thing. Don't worry about it. It's all good. Now, remember, Indiana is in the 7th Circuit, so this eventually would get to the 7th Circuit. Maybe it goes to the Supreme Court. And the Supreme Court says, no. If you accept the commutation, you're good. You don't have to worry about anything. Whatever you do, you're fine. You're playing with house money at this point. By that point, Trump will be president. Biden will no longer be. Can they go back to those commutations still and accept them? I don't know. So the idea of, yes, you can refuse a commutation, sure. But what happens if you accept that commutation, I don't think is clear for them. And there's a problem. So it's not the issue of accepting it. It's what's it going to do for me later and what's it going to hurt? What are the secondary and tertiary effects of it? So they're making a pretty big gamble here. It's going to be interesting to see how it shakes out. Like I said, I just thought this was really cool. You know, they're refusing it for very interesting reasons.